So, sorry for a small delay, and I welcome everyone. My name is Pawel Rosikiewicz. I'm a founder of SwissAI and main organizer of this meetup. So, I wanted to, just before we start, tell you a little bit about our organization and what we do. So, basically, we do events at every 3 to 6 weeks. Where we invite people from IT, from computer science, but also from personal development, and focusing our talks on data science, machine learning, and artificial intelligence, or this field in general. We have a team of people, so you can see here Clement with camera, there's Chris who is making interviews with people, and we are starting a series of interviews that's gonna to be available at our webpage, SwissAI.org. And you can always visit this webpage, see the newest event. There will be always a link you can register for. All our events are for free, and you can always come and join us. We also have a YouTube channel, so a few weeks after this event, this lecture will be available online. And we are publishing our videos every Tuesday or Wednesday at lunchtime, so you can eat and watch our lectures. And we also have a Twitter account, so you can follow us if we have something new or some smaller event, like small apero networking event, to join us at any moment. Besides the big events like this, we also have something what we call focus groups. And these are meetups where we meet on specifically to talk with more machine learning jargon and more focusing on models and implementations. You are also welcome to join us for these events. And typically they are announced with a shorter term, like 15 days before or 10 days before. A little bit about upcoming meetups. So we are planning another meetup at 15th of October, and it will be about fourth industrial revolution, which is caused by AI. And we're gonna to present talks by the member of World Economic Forum, and after presenting some startups from Canton Vaud, which build their products around the AI, in AI with their core. And after this, we gonna to do 2 more meetups in this year, big events with more technical talks on deep learning and reproducibility in machine learning research. So now I would like to present you Michel Jaccard, who is really like one of the most distinguished guests we have here. And he is a lawyer working and specializing in IT law, machine learning, or generally in digital world. So he graduated from University of Lausanne, from law school. And after this, he actually got to Columbia Law School on Fulbright grantee. And now he is a founder and partner and president of IDES.
General-in-Chief of the armies and senator for life, and a partner at the law firm.
And one of the most known law companies in Switzerland, which is basically helping to startups and high-tech companies to go through the meanders of law, and as I heard, doing a very, very good job. So even some companies which are presenting here were clients of our speaker today. Besides being a lawyer, he is also a lecturer, and with 19 years of experience, where he's lecturing mostly on intellectual property law and internet. And he's also helping to students. So if there are students here, they can be interested in, how do you call this, grants? What is the name of this grants?
Strategist Prize.
Strategist Prize, up to 50K grants for young small companies and startups, and funded by HEC and EPFL. And also he is a blogger and blogging a lot on Bilan about law and digital world. So please.
Thank you so much, Pawel. Thank you, everyone. Very happy to be with you here today. Let's try and not lose all credibility immediately. Yes, I managed to do that. We're going to talk for 30 minutes or so about AI and privacy and the relationship between the two, especially under the European Data Protection Law, the GDPR. So this is basically, the catchphrase for the firm I founded a few years ago. What has not been said is that I did some programming with Smakies. Smaki, the pride of the EPFL computer that was developed here in the 90s, 80s. I also did some coding with TRS-80 and ZX81. That's a long time ago. I switched to the law, but I always love computers and technologies. Okay, so this afternoon is going to be about setting the stage. My job here is to warm up the room for you to ask questions to the real guys coming after in real business cases. We won't be able to avoid a detailed analysis of the GDPR. I tried every possible way to present you the GDPR, so the European regulation, in a way that should be funny. I've failed, desperately failed. So please bear with me, but I'll try to do my best in the coming minutes. And of course, the way forward. So everything starts in Europe regarding data protection in 1950, so 60 years ago. And then you start saying, wow, gosh, one of those boring lawyer presentation with a lot of text. And you would be right. So it was easy in the 1950 because I can basically summarize what is in the European Convention on Human Rights. Article 8 just says, leave me alone. I have the right to be left alone. This is the key provision, the European approach to data protection. Just leave me alone. Then, you need to wait for another 30 years. And you have the European Convention, Council of Europe, 1980. Very detailed text. I'm sure you can read it. I have no pointer. So why not go directly to the summary, personal summary of what is in this treaty. Basically, it says, please just let me know if you let computers process any of my data. And, by the way, if you can tell me who you are and basically why you're doing that, would be good. Please, tell me. But I have no way to force you, no meaningful way to force you telling me that. But please, it would be nice if you can tell me about that. Let's wait another 15 years. European Directive 95/46, we're in 1995. Even a more detailed text. So you see the increase in the amount of texts developed by the lawyers decades after decades. So I'm sure you can't read that text. What about the summary? What is in the European Directive in terms of data protection? And of course, machine learning and automated processing. This is my focus this afternoon. It says basically, I can prevent you, dear technology, dear company, from making decisions impacting me based on profiling. Unless I have asked you to. You take my view into account, that's the legal wording, and you've got some measures in place that are supposed to, protect me. Oh, and you know what? I may want to know what the logic behind your system is. This is the first hint that basically, as a data subject under European privacy laws, you have a right to basically understand what's going on. But you still have a problem. You need to kindly ask, please tell me. My point is, here, there was no law that basically would actually be enforced because there was no significance and actual consequences to breaching those laws. So it's always, please, give me some explanation. Or what? Or basically nothing. So 21st century, we're now in 2018. The world famous GDPR. You have all heard about the GDPR, right? Dozens of times. So this is, again, a GDPR presentation. I'm sorry about that. But maybe there has been some progress between the last attempt end of last century into end 2018 to address properly machine learning from a legal perspective with the focus of privacy. What has changed between then and now? First, frankly, machine learning is now a reality. It was not so much a threat or a reality in 1995. It is now a reality. Second, you had the ambition of AI growing, but you have the ambition of privacy evangelists growing too. Think of that. This is the quote of recital 4, the preamble, if you want, of the GDPR. The processing of personal data should be designed to serve mankind, nothing less. That's a bold statement, right? Competing with AI. AI has also this kind of ambition. So who's going to win if we need a winner? Another thing to remember that in 2018 you have this GDPR that is, European legislation, but basically the impact and the influence of the GDPR goes well beyond Europe. It raises the bar, it sets a new international standard. So of course in Switzerland you have some situations where you're obliged to comply with GDPR, but the reality is that there is pressure from the market to step up already your level of compliance and basically to address GDPR concerns in any project, including AI project. But the real difference between the GDPR and the old text, one of the major changes is that if you do not comply, then you're in trouble, financially speaking, because there are actual fines, actual consequences linked to non-compliance with GDPR, which was not fully the case under prior legislation. So this is the change, basically, where now companies need to take privacy seriously. What has not changed, unfortunately, between 1995 and 2018 is that those laws are still written, can you imagine a worst combination? Written by politicians and lawyers. What did you expect? Did you expect a law that you could understand? And this is really, really an issue, especially in this field of AI, interaction between AI and privacy for the GDPR. Okay, so this is about the European approach to privacy. Everybody's ready? Let's jump into the GDPR. There are many provisions in the GDPR that deal with machine learning or automated data processing or what you should do with automated profiling. I have listed here the provisions, and we go through some of them in more detail. So, Article 22, this is the core provision. Several articles dealing with rights of data subjects, access to information, of course, an article dealing with definitions, another one with sensitive data, because this is tonight about more, health-related data than general data protection, and a lot of recitals. And to add complexity, you have the interpretation of the GDPR by bodies that basically have some weight. When they write a white paper or when they write an opinion, then you better read that to really understand what the law would say. Yeah, so the Working Party 29 guidelines endorsed by the newly created European Data Protection Board. Okay, ready? And I have no pointer. It's going to be hard. I have to jump. So, Article 22, first paragraph. This is the result of years of negotiation. Can we read that? The data subject. So the data subject is at the center of any privacy regulations. You, me, us. The ones the law wants to protect, okay? The data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or similarly significantly affects him or her. This is the core provision regarding machine learning for the GDPR. Years of efforts to get to that, right? So the first item I would like to point out with you, discuss with you, is, when I read that, it says the right not to be subject. Is it a prohibition? Or basically, if you're an AI company, you can start by saying, working assumption, I'll do that, and if anyone objects, then I'll stop. High stakes, because, if it is interpreted as a prohibition, then, it is up to you to defend yourself and prove that you complied with the law if there is any issue. If, on the other hand, you interpret this wording as a right to object by a data subject, we're all sheep, as you know, all those privacy policies presented to us and we consent. Maybe there is, 3%, 5% of people objecting to this kind of stuff. So it's a different business model for the AI firms. Guess what? This very central question is not settled. So as we speak now, nearly four months after the entry into force of the GDPR, we still don't know whether Article 22 and the limitation to machine learning should be interpreted as a flat prohibition of any machine learning except in very limited circumstances, or something that can be undergone until someone objects. My personal view is that it should not be considered as flat prohibition, because otherwise it would be extremely difficult for AI companies to navigate in Europe. But this is the first issue unsettled because of the wording that is not precise. I don't want to go into the details, but you have other provisions that say this processing shall be prohibited. This is not the wording that is used here. So, people think that, if there is a different wording, then it means that it should not be the same situation. Okay. The little guy here, I'm very proud of having put something else than text in my presentation, is how can you escape from the burden of GDPR and Article 22? You can run with the money, right? So, it's the AI company hiring a lawyer to, I'm not comfortable at all with this GDPR regulation. How can I escape the regulation and the privacy regulation? So what are the other elements of Article 22? Data subject shall have the right not to object to a decision. So this is the scope of application of Article 22. So, you do not need to have studied law for years. It means, a contrario, that if there is no decision, there is no application of Article 22. So if you use your machine learning processes for evaluation purposes only, rather than leading to specific decisions, you do not need to care about Article 22 of GDPR. Smart lawyers, right? Smart legislation. Please do not forget that even if you're not subject to Article 22, you are still subject, you may still be subject to other provisions of the GDPR. It's not one provision or nothing. But the key for you as an AI company is, do you have to follow the very strict requirements of Article 22, or can I escape that very specific regime? So your answer would be, my machine learning AI system helps me better serve my customers, but certainly does not take decisions impacting individuals. One of the key triggering items for Article 22 to apply is missing. I'm out. Data subject shall have the right not to be subject to a decision. Oh, not any kind of decision. Decisions that produce legal effects concerning the data subject or similarly significantly affects him or her. What on earth does that mean? Nobody knows, right? So it needs, thank you so much for giving us more explanation, dear working party. So what more guidance we have is only serious, impactful events or decisions that have the potential to significantly affect the choices of the individual concerned. All other decisions are not subject to Article 22. So your defense would be, my system helps me better serve my customers, but does not take decisions. At least, maybe there are decisions taken by my machine learning system, but those are really tiny decisions, not impacting in a meaningful way individuals. Second, escape possibility from the privacy regulation. Well, wait, there are other escape routes. The decision leading to a strong impact on individuals needs to be based solely on automated processing. What does it mean? Because, of course, if basically you get the wording as it is, you could say, I've got some human being left somewhere in stock, which at some point in the process is reviewing what the machine outcome is, and that person, even if artificially present, is doing some stuff. So I'm out of Article 22 because this is not a decision solely based on automated processing. I have human involvement. No application of Article 22. The interpretation of this clause is not settled, meaning that some people think, fabricated involvement will not fly. So if it is artificial to put human beings back into the equation, but not required or without meaningful involvement by that person, then that would be considered as an abuse and not be sufficient to escape the consequences of Article 22. But there is another issue. if you need to prove what is the human involvement in such a machine learning process, who needs to bring the burden of proof? And in the law as it is written, it is the data subject. So the data subject you want to protect basically will need to bear the burden of proving that human involvement is fabricated or just there to escape the consequences of Article 22. You're still with me? It's not finished. Still on those, very few lines of codes, of legal codes, with all the possible mistakes or issues when compiling that and trying to translate that into actionable items. The decision needs to be a decision to which I have not objected. It needs to be solely based on automated processing and have very strong effects. What is automated processing and profiling? So there are less interpretation, you have definitions. You need to understand that when we talk about automated data processing in Article 22 GDPR, it's just very detailed individual profiling. Group profiling does not trigger the application of Article 22, right? So what am I telling you? I'm telling you that if you are an AI company in Europe and you really don't want to hear about GDPR, and you don't want to have the burden of regulatory compliance, it's that decision tree. My personal view is that you need to prove or you need to set up a system where basically you use your machine learning systems for evaluation purposes, or you get some human doing something, or you just apply your machine learning technologies and algorithm to something that does not lead to very strong impact, full of impact decisions for those individuals, or you do just general profiling, or you don't use any personal data at all. You just use statistical data and anonymized data. You're out of GDPR. Or you let the claimant, so the data subject, prove that the conditions are satisfied. Or you can even think that this is not about a prohibition, it's just a possibility for the data subjects to object, and you let them come to you and object, and then you deal with that. So a lot of possibilities for you as an AI company under European privacy law to escape the very strict regime set up by Article 22. Now, that was only the first paragraph of Article 22. What did you expect? Okay. Come on. So of course, what I'm doing here is a kind of a summary. It's a 101, so I have to make choices. But the point is, the prohibition or the limitation of Article 1, of the paragraph 1 of this article, do not apply if you get the explicit consent of the data subject. Wow, another escape route. You get the explicit consent, you can do not whatever you want, but still you have much more leeway compared to the strict limitation that I have mentioned. And I have here a footnote that says, regarding health data, the other stuff will not work. You need explicit, specific purpose consent, freely obtained consent by the data subject to do automated processing and so on. But for those exceptions to work, so you have the general framework, you can't do a lot of things, except if, paragraph 2, you have some exceptions. In particular, explicit consent from the data subject. But for those exceptions to work, you need additional safeguards. That's paragraph 3 of Article 22. And basically, it says that if you rely on consent, and for that consent to be valid, it needs to be, explicit and just detailed and focused on something. But you need also to give that data subject the right to obtain human intervention on the part of the controller, so the data controller. You have the right to express your point of view and to challenge the decision. So that's interesting because from a legal perspective, the assumption is that humans will make better choices than machines, right? If you think about that, even if you comply with all the requirements of the GDPR, somehow the law tells you, let a human review what the machine has decided, and you have the right as a human to engage with a human on the other side to challenge the decision and ask that the human being intervenes. And the assumption is that the result would be better. But the problem from a legal perspective, I'm really sorry to go to that kind of details, but it is key. You have Article 22, paragraph 3. I have here underlined the relevant part, telling you about what you can obtain as a data subject. But then you have part of Recital 71, so part of the preamble of the GDPR, that tells you something else. You have the right to obtain human intervention, express your point of view, to challenge the decision, but they were not even able to align their text between the preamble and the body of the GDPR. You have the right to obtain an explanation of the decision reached after assessment. This is part of the preamble of the GDPR. It's not part of the articles themselves. How do you interpret that? When you have a preamble in an agreement, usually you can't rely on that to have enforceable rights. You need to look at Article 1, Article 2, Article 3, not the preamble. So nobody knows about that. But this is interesting, because if you read this Recital 71 in connection with other articles of the GDPR, 13, 14, 15, they tell you that as a data subject, you have the right to obtain meaningful information about the logic involved. So the question for you is, and this is key for the development of AI companies in Europe, as a data subject, am I entitled to a kind of a general functional description of how the system works ex ante before any decision is taken concerning me? Or am I entitled to actual explanation by a human of how my specific decision impacting me has been reached? It's not the same thing for AI companies. In the first scenario, you prepare some wonderful white paper, some video, some stuff that explains in general terms how that works, what are the criteria involved, how you build your database, what is the logic behind that. But you don't have to disclose the very specific functioning of your machine learning system. In the other case, and if you have someone being able to convince the courts that you have the right to get the details of the specific decision or the reasoning that led to the specific decision, that of course it is another situation for AI companies. My personal opinion here is that you should reach and target transparency as being the default rule under EU law. Even if this situation, ex ante explanation or ex post justification is not settled, you will win the trust of your users by basically allowing them to have access to a certain extent to the understanding of your system. But it might not be for purely legal reasons under Article 22. It might be because you want to basically build trust with the users of the system, or you want to comply with other provisions of the GDPR. We're nearly there. But of course, there's another question. Fine, so now I understand that I need to disclose something to this stupid data subject who will, of course, never understand how I got to that conclusion. And guess what? Maybe I'm not even able myself to explain how we got to that very specific conclusion, especially with neural networks. But there is another issue. If I talk to my lawyer, that guy will tell me, are you crazy? This is valuable proprietary technology, trade secrets. Are you really willing to disclose your algorithm? How can you convince investors to invest into your company afterwards? Remember, we have a patent pending on that. So on the one side, you have privacy requiring, in the best case for you, general explanation of how that works before any decisions are taken. Worst case, very specific, detailed explanation to a data subject regarding a specific decision that was taken. But in both situations, you take the risk of having to disclose very sensitive information. Luckily for you, you have one of those recitals helping you. Again, not in the text of the GDPR, so it's still unsettled, but in the preamble that says, that's right, and I put to an explanation, it's more complex than that, but that right to basically obtain information regarding the logic or the decision that was taken should not adversely affect the rights of freedoms of others, including trade secrets or IP. and in particular the copyright protecting the software. So it's not in the text of the GDPR, it's in the preamble. But there is a clear indication that you cannot rely on privacy alone as a data subject to require algorithm disclosure, which is, of course, relief for many AI companies. So clearly there is a balance to be found. Last slide, takeaways. If you look at Article 22 GDPR, you just shut down your AI operations in Europe. You stupid Europeans, they have not understood a thing about the potential of this technology. Forget it. Go further than that. There are many unsettled provisions, many unsettled interpretation, and many escape routes available. You remember the little guy running with the money? That's about, tips about how to escape Article 22. Of course, over the years, and over the next months, we'll know more. If there are some cases, courts will help us interpret the different issues. One of the key issues is what is the level of detail and when do you need to share some information with the data subjects if you use AI or machine learning systems to make decisions about them. The consensus in Europe seems to be that you don't want to wait for those court cases, And maybe you saw SAP last week issuing publicly a kind of 7 principles regarding ethical treatment of AI. And they included privacy, part of that. So clearly, privacy needs to be taken into account into any design of machine learning system. I'm not sure if that's because of fear of GDPR non-compliance or because that's better for the trust you can build around your system. And there is also some relief in the fact that privacy shall not prevail over IP and trade secrets. Okay, that was it. Available, of course, for questions. Thank you.
Thank you for the talk. My question is, what is really at stake? It depends on the infrastructure of the service you are using. If we are in e-health and there is a bad diagnostic, I can reconcile what you say. And on the other hand, if it's only for digital marketing to be targeting you accurately, there I think you are really right that we need to be involved with setting our own preferences. So now, where do you set, how can we split those two categories? What has to deal with e-health and that is critical, and the rest that is just consumer enhancement?
Thank you for the question. So if I try to summarize it, is it really GDPR, is it really a one-size-fits-all, or should we need to basically, or it would be better to try and address specific circumstances and specific scenarios differently? Maybe we should not have the same kind of protection for e-health related AI projects, really basically, dealing with the core of sensitive personal data. And maybe we can have some lighter or different rules, or are we really allowed to or obliged to follow that for direct marketing or newsletters? This is a kind of how I understand your question. The choice made by the European Union is to have a kind of a framework with the GDPR. Totally different than in the US, where they have verticals. I think that the choice made by Europe is the right one, because it is extremely difficult to determine from an individual basis what is important for someone and what is not for another person. Think about financial information, credit card information. For some people, they will not care disclosing that to a certain extent, or date of birth and age. For people, it's not an issue. For other persons, it might be really something that they consider as being totally private. So the framework needs to be equal for everyone. Now, how can you really provide flexibility into that framework? The idea is, of course, it's privacy by design, by default, meaning that the data subject should be the one making those kind of decisions, with the result that the protection might be lighter in certain circumstances, heavier in other circumstances. My personal fear, so the tools exist, but my fear is that this GDPR relies still heavily on consent. So the assumption is that data subjects are able to understand the complexities of this stuff and make the right consent. I think this is exaggerated, and we should provide some protection without the possibility to waive all the protection through consent, because we know how this consent is obtained somehow. It's just, read that, oh, I'm tired, so I'm going to accept that. Welcome.
Thank you for your talk. Actually, I found that you did it pretty fine.
Thank you.
Okay. No, my question is simply how you see, let's say, large computer manufacturers or companies, mostly GAFAs in the US, how they are reacting to that, which sort of things they are implementing inside to follow this regulation. You mentioned, for example, the SAP, that's something is being done everywhere.
Yes, so the question is, is this legal text that is quite aggressive compared to what was in place before, especially because you need to pay some fines if you don't comply, will it really have an impact on the business models and the thinking of the guys at GAFA, and whether it's going to change anything? I think it is a very good question. I'm not sure that Europe has been able to really push actively the US companies to change their business model. My perception is that they are still trying to find escape routes, and they do not take European privacy laws seriously. Of course, they take it seriously. They are going to comply with the law. And they are very honest in this attempt, but they are not going to go beyond and really think what is best for their customers. And GDPR will not be sufficient for those established companies and the GAFAs to really change their business models. My hope is that those big companies will be pushed and disrupted and forced to change their practices, not because of the GDPR, but because of young, innovative companies that will not only comply with the law, which everybody should do, but will really address the concerns of the customers, of the market, and the fears of the society. Those are the ones who will really put more pressure on the GAFAs than legal text.
That kind of disruption to their business model can come from, let's say, outside.
Yes, and it's much easier to set up a proper AI system when you're a startup than basically trying to change things that you not ideally coded or designed in a huge company platform listed, where you just do a little change and you have blogs over the place, activists, shareholders complaining about everything that you do. If you're a startup, you are agile. Now, you should be a startup not willing to be sold to those companies, because the way they address this threat is to basically acquire those startups with a lot of cash and stock, so that they do not pose a threat. But I'm not sure they'll be able to do that for a long time still. Welcome.
Yeah, good. Thank you for your talk. Could you talk a little bit more in the context of healthcare?
Yes.
And how, as an AI startup, when we're looking at healthcare, we're trying to get the data, we're trying to build our data sets. Most of that information it's data. So we're grabbing files, we're grabbing imaging files, x-rays, we're grabbing CT scans that a patient would not consent to now because that information wasn't available, the technology wasn't available. How does GDPR affect grabbing old information from a hospital source, using it for your data set now to improve your technology that you're trying to release for the future? And how's
From my experience and just experience assisting startups in this ecosystem, the big issue for startups is that they do not have direct access to the data subjects. Because if you have the possibility to directly interact with the data subjects feeding your database or providing you with information, that's fine. You can explain to them what you're doing, why you're doing it, how you're going to protect their data. And you have a direct exchange and they consent to it and you can be transparent. The problem is that as a startup, you're relying on other intermediaries, hospitals, private physicians, universities, and those guys are not clean about their own compliance with data protection. They don't want to go back into the past and reach out to every single person having participated to trials or questionnaires or tests in the past, because they are not entirely sure that they did things right. So they will be reluctant to help you achieve compliance and transparency. But you need them in most cases because you don't have the resources nor the positioning in the ecosystem to basically reach out to them directly. So it is about convincing, and it takes time, convincing the hospitals, convincing the intermediaries that it is also good for them to try and help you clean up their database so that you can work with clearly information that is clean from a legal perspective. The way to do it is to propose them to do the job on their behalf. So meaning, give me access to your data set, I'll make my own analysis from a legal perspective, and I will tell you what you can send me for me to use. But they are reluctant to let startups enter into their data sets because they fear that startups will be more accurate in determining what is compliant or not. So no clear answer to that. It takes time. And in every possible business model, try to get to the data subjects directly rather than relying on intermediaries, if you can, of course.
So one of the points of GDPR is to guarantee a certain level of support to the customer, in particular the fact that they will not be judged by a machine. Complying to that should give a certain reassurance to the market. In these few months when GDPR has been applied, have you been exposed to any competitive advantage that has given to European companies in comparison to companies outside Europe? So in other terms, can GDPR actually be used to increase adoption of AI?
If your customer base is in Europe, the easy answer is you don't have a choice. GDPR will be a competitive advantage, but it will also be the minimum required. What I witness now is basically requirements by any institutional customer to require from any technology supplier, including startups, that they comply with GDPR. So for the European market, it's no more an option. For the Swiss market, yes, it can be perceived as an advantage, competitive advantage, but it's still a question mark. It's still unsettled. That was the hope, basically, that basically this GDPR would put forward would increase the cost of compliance for many European companies, but would also basically reassure the market that if they are GDPR compliant, that personal data is better processed and protected. It might be the case, but I have not experienced that in a very clear way. Not yet, at least.
If someone has one short question, 1 minute.
Just very short. Has anyone been fined? Is that in process anywhere? How soon will it happen?
Yes. Yes. In Europe, certainly. In Switzerland, we're somehow, protected for a few months, because there is no procedure and no process in place in the GDPR, basically, to make sure that you can get your hands on Swiss companies if they do not have a presence in the EU. But yes, you have, of course, the big guys being sued. Facebook and Google and so on, they were sued the day of entry into force of the GDPR. But that's basically, they are sued every week. So it's part of the business model. But we start to see the first enforcement actions at the national level for SME companies coming up, yes. No, you can't rely on, you maybe still have a quarter, 3-4 months to basically make yourself compliant, but you can't rely anymore on the fact that you won't be sued.
Thank you very much. And we'd like to thank you again.
You're welcome. Thanks to you.
For you.
Thank you.
And the wine will be on Aperol, which we have after 2 more talks. So there is a tiny change in the plans. Right now we're planning the